See? Or, this is often the case, the company in Turkey says, I'm going to hire some really great folks in the United States. They're going to sell our products like crazy and make us tons of money. I want to make sure they can be owners too. And maybe we also have a local partner that we're not going to create quite a joint venture, but I want to give them 10% of the company. So everybody feels like they're participating. So you can have foreign company owning 80, key employees owning 10, local partner owning 10. Now the beauty of an LLC is you can have different types of ownership. The foreign company can own 100% of the voting shares, called units in an LLC. And the key employees and the local partners can own 10% each of income shares. So when they distribute out the income, 80% goes to the foreign company, 10 to each of the employees and local partner. But when it comes to making decisions on how to run the business, the foreign company can have 100% of the vote. There's all kinds of complexities with that. The beauty of an LLC is it's a creature of contract. So you can contract with your fellow members and make any kind of arrangement you want. Think of it like a partnership. So there are many LLCs which have A units, B units, C units, whatever the mind can imagine. Okay? The companies are governed somewhat similarly and a little bit differently. C corporation has shareholders. They're the owners. Okay? Shareholders appoints a board of directors to act on their behalf. If you're representing a foreign company, you're going to ask your client, who do you want on the board? Typically you want an odd number, so if there's a vote, you don't split it 50-50. That board can be non-U.S. citizens. It doesn't matter. You don't need to be a U.S. citizen to be on the board. The board appoints officers that act and do the day-to-day activity in the company. You'll need generally at least two, a president and a secretary, because your bank's going to want you to sign documents which require the secretary to authenticate the signature of the president. Beyond that, you don't need any other officers, but you may want to have others, treasurer, vice president, what have you. So the shareholders own the company, the board is the representative of the shareholders, and the officers operate the company at the pleasure of the board. LLC has two distinct ways to manage itself. The LLC, as I said before, doesn't have shareholders, they have members. So the members, the owners, can manage the business themselves. In the example I gave before, the foreign company has a 100% vote, they get to decide everything. Or the foreign company can say, I'll appoint a board of managers. And that board maybe is going to have one representative from the employees, one representative from the local partner, three representatives from the foreign parent, and they will manage the company, and they may vote 50-50, they may vote, the simple majority 51-49, they may say 65-35, depending on what kinds of things they want to do. Frequently we are asked by clients, should I sit on the board? Should I manage the company? Am I going to get sued personally? Remember, that box protects the owner inside the box from liability. Generally, there's no personal liability for a board member or a managing member or even a member of an LLC as long as they act within the scope of the corporate entity. Okay? If they act outside of it, they do wrongful acts, intentional acts, they breach fiduciary duties, act bad in a big way, make it simple, they could potentially open themselves up to personal liability. But if they act and maintain their fiduciary duties, which I have here, loyalty, care, good faith, fair dealing, meaning they don't try to double deal. They're trying to, they're on the board of the company, their obligation is to be loyal to the company, but yet an interesting deal comes along and says, well, maybe I'll do this deal on the side for myself. That's a breach of loyalty. You can get sued for that. Okay? So if you stay in the box, you're good. Who is the client, in essence, of your client? Who do you owe those duties to? If you're in a corporation, you owe the duty. If you're on the board, you owe it to the shareholders. You owe it to the corporation as a whole. And sometimes that gets a little tricky because you may have divided loyalties among the shareholders. One group feels one way, one group feels the other way. Your job as a board member, an officer, is what's best for the company. And you get a lot of protection under the U.S. laws if you're fully informed and you use good good judgment, good business judgment, it's called the business judgment rule, you will not get sued as long as you maintain that. If a company, this is a difference between the U.S. and Europe in many respects. If a company is solvent, you don't own any duties to your creditors. As the company shifts towards insolvency, the duty to the creditors also comes in. So if you're on the verge of bankruptcy, who are you working for? The banks and the other creditors are as important in your fiduciary duty considerations as the corporation as a whole. Again, you don't have personal liability for trading insolvent as long as you maintain your fiduciary duties. In other countries, if you're trading in an insolvent entity, board members have personal liability. That's not the case here. Just quickly, you can have different classes of stock, different member interests. That's what I talked about before, different things. I'm going to quickly go through employment issues because it's really important. This entity, once it's set up, is going to start hiring people, right, to work. New York and most other states are employment at will. You can fire somebody because today is Friday and it's cold and I'm grumpy and I just, you're out, okay? I can't fire you for a discriminatory purpose. I can't fire you based on age, gender, so forth. But if that's the case, do you need a contract with people? Yes, you need an employment contract because without it, you can't build in certain other protections like duty of confidentiality, ability to restrict them from soliciting customers and other employees if they leave and go elsewhere, and potentially the ability to restrict them from taking a job with a competitor. And I'll tell you, and this is, foreign companies don't appreciate this sometimes, even though you draft a contract that has a non-compete provision that says you work in my clothing company, we make performance apparel, you can't go to any competitor, many, many judges will not adhere to or respect or enforce that provision. They will reduce it down or eliminate it completely. And the reason is there's an overriding public policy in the U.S. to allow people to work, particularly in their field. So a judge will try very, very hard to allow that person to go work and not hurt the company at the same time, but if it comes down between two equals, the judge is going to favor the employee every time. So why would you have it in your contract? You have it because it definitely makes the employee think twice about going to a competitor, and it certainly makes the competitor think twice about hiring that employee, particularly a senior employee, because if the competitor's smart, they're going to say to a prospective hire, let me see your employment contract from your old employer. And if there's a non-compete provision in there, that many times will stop that new employer from bringing on the employee because they're going to be party to the lawsuit also. So non-competes are important. The last thing I'll touch on is work for hire. Anything an employee does for a company, even if they're on the payroll, if they develop software, they develop a design, they develop any kind of intellectual property, our intellectual property laws say that invention belongs to the creator, to the employee, even though they're on the payroll. And employers don't understand. I paid you. This is your job was to create the software. What do you mean I don't own it? No, you don't. So you need to have in the employment contract a provision for work for hire and assignment of any inventions so that it's very clear that that employee has given away its rights to any of those intellectual property creations. And I have another minute, or I'm done.
No more than a minute.
All right. Quick minute. Department of Labor. Our government doesn't have enough money. Our states don't have enough money. We need money, money, money, money, right? So where did they get it? From employment taxes. Companies, particularly foreign companies, particularly startup companies, are very interested in hiring people who are quote-unquote independent contractors, which means you're not an employee. I don't have to pay my portion of the employer tax on your wages. So it's about a 7 to 9% savings. So it's very attractive to try to classify someone as an independent contractor. And our government, state, local, federal, will come in and say, let's really see, are they not? Because they want the money. So they will look at what kind of control do you have over the person? Do they work in your organization or do they work from some other location? Do they have their own company that they work from? Do you supervise them daily, all these different factors to see, are they really an employee, or are they really, you know, like you'd bring in a business consultant for a short period of time to help you, you know, organize a website or sales tactics or something like that. They are biased towards considering these people as employees. There are penalties, there are additional taxes, and it is very much a hot topic to be careful about whether you want to have somebody as an employee or classify them as an independent contractor. Okay.
Thank you. Thanks very much, Roger. We have time for a few questions, a few minutes. Any questions?
We have a mic here if anybody has questions, please.
Oh, and over there also.
Hi. I have a question about LLCs.
Yes.
I know that it's a pass-through company, so the company members they don't pay taxes.
Correct.
My question is, if the members do not reside in the United States, and other than franchise tax, who pays the taxes in the U.S.?
The tax is paid by the owner of the LLC. So if you have a foreign owner, that foreign owner will have to pay tax in the United States. Okay. Most countries, there's a tax treaty which will recognize that whatever tax was paid in the United States is credited against the tax that would otherwise be owed in the foreign jurisdiction. There are some countries, and I apologize, I meant to look this up for Turkey, but I know in England, for example, England doesn't recognize LLCs as pass-through entities. So there's some structuring that we do to create a little bit of extra layer so that we can get the tax treatment for a UK owner of a US LLC. But generally speaking, there's a credit.
Okay.
Thank you.
Thank you.
Next question?
Mine is actually another question, but more like a comment. For the attorneys who are dealing with Turkish clients, I'd like the attorneys to pay more attention to have the clients have their corporate documentation ready. Unfortunately, the companies who are coming from Turkey to the United States are not really ready or used to the documentation that are different in the United States. So that comes in front of the banks like us as a challenge. It's difficult to educate these customers and the clients for us, and for you, attorneys have a big role in this. You guys need to educate your clients to the system differences and make sure their corporate documentations are okay, and they're very well aware of the loan documentations that they're signing. So this is a challenge for all of you. So I think the conversation in these kind of conferences should be more to educate attorneys like you. Maybe they will all learn, they will all learn what the LLC structures or what they would do with the lawsuits and everything. This is not the challenge that the companies are facing. There's a huge difference between the Turkish law about how they're registered, because in Turkey they're registered to the Turkish Official Gazette, and that's enough for them to be identify who the owners are, who the shareholders are, who are operating on these companies. But in the United States, it's not like that. So you need to educate your clients about this, so when they're dealing in the United States, there's a huge difference. This is my comment.
Thank you very much. One more question here.
Is this one? Yeah,
Yeah.
it's working. Among my clients, it's significantly common if they do have the Turkish background and they are so eager to start trading with the United States, or I would say with any other country, they may just not sign any contracts, and the transactions would start without anything. And it's very common that you may send a couple of emails and the products are already shipped from Turkey or bought from the United States. So if you would please point out briefly for us the pluses and significant minuses to start trading with the United States without the valid contract in writing, and what would be the consequences of the clients?
Well, I'll address that for a second. I've had experience with that, and actually it's very common, as you say. Turkish businesses and have a lot of trust in doing business by word as opposed to and trust as opposed to having it written down in a contract or in contractual form, and the results are usually or often, or when I see them anyhow, disastrous, because it's very difficult to enforce those contracts, and people wind up saying, well, I trusted him, I knew him, or et cetera, et cetera. I don't know what the experience here is, the other experience.
It's awful. Awful for the client, maybe good for the lawyer because we can make some money. Courts will enforce an oral contract, but the fight then is, well, what was the agreement? And, you know, then you start piecing together emails and course of conduct and all kinds of extraneous pieces of evidence to try to prove, well, this is what we agreed upon. Obviously, if you have a clear, well-written, thought-out contract, you can enforce it much more easily. It doesn't make it perfect, because our job as lawyers, if Michael and I were on the other side, we'd each have a different way to read a contract, I'm sure. But yet there is a document that everyone can point to, so it's critical, just with respect to the other comment, like have your corporate documents in order, sign contracts, and don't modify the contract either. I litigated a case for a year and a half because we drafted a consignment agreement, foreign company with a U.S. Agent, and a year into it, they supposedly agreed to change the commission schedule. Well, they didn't put that in writing, so we litigated and spent hundreds of thousands of dollars to prove what the commission schedule was.
Well, let me add something. It is often the case that clients view lawyers as, at least initially, an unnecessary expense, an unnecessary obstruction, as a class of people who don't understand business. And just following on the comment of the earlier questioner too, if you add to that, which is a universal, transnational starting point, a different legal experience, it's unnecessary in Turkey to do anything other than have your corporate status published in the official gazette, for example, then it's a difficult challenge. And it's not only with respect to small companies or startups getting a basic contract or a basic set of corporate organization documents is the first hurdle, but then convincing your client that it's helpful to add some detail, choice of law, choice of forum, things like that. Again, if the starting point from the client for the client is, there they go again, those lawyers looking to make things complicated, looking to pad their own purses, it's problematic, and it's another challenge for all of us in the room who are representing clients from any place, but especially clients from a different culture.
Thank you very much. I'd like to thank you all for attending and thank the panelists for wonderful presentations, and I hope you enjoy the rest of the seminar.
Thank you very much, Mr. Wise. At this point, actually, we have a little token of our appreciation for you. And for that, I would like to invite one of our co-organizers, a valuable member of our team, Mr. Remzi Güvenç Kulen. Remzi, if you can present the plaques of appreciation. Thank you.
Oh, wow.
Oh, thank you so much. Thanks very much. Thank you. That's lovely. That's beautiful.
Thank you very much, Remzi. Thank you very much, Mr. Wise. Let's take a break, but let's not keep it at 15 minutes. Let's keep it a little bit shorter because we're running late. Time is 11:25, so why don't we meet here back at 11:35 for our second panel? Thank you.
Ben bu başa oturuyorum. Siz böyle oturun isterseniz.
Ben konuşmamı şuradan yapacağım da PowerPoint'ıma bir bakabilir miyim acaba? Could you please help me for my PowerPoint?
Orada gözükmüyor mu hala? Desktop'ta mı?
Ne?
Şuna girebilir misin?
Şu mu?
Tamam.
İki zaten şu anda girdi benim. Yok olmadı.
Çünkü biraz önce
Sorry? Yes, I would like to see what I'm doing because if I look at there, then I will confuse. Okay. Okay. So I have to use this one or this one? Okay. Okay, thank you.
Orada bu kağıdı rica edebilir miyim?
Ah,
O benim notlarım.
ben burada
Tamam,
şey
hemen
yapacağım.
kaldıracağım. Siz bir oturun.
Tamam.
Ben şey tanıtayım.
Benim şey.
Batırırsan PowerPoint çok da şey yok.
Öyle mi? Tamam. So you wrote this convention?
I wrote the book. I didn't write the
Well, welcome back, ladies and gentlemen.
I mean the book, you wrote a book.
Welcome back.
Yeah, and this one.
We're so excited to have such wonderful speakers today. We would like to move to our second panel. Like I said, we're running a little late, so I'll just have to cut your coffee break a little short. Sorry for that, sue me. Do whatever you can, but we have to do this. We have to move on. Our second panel is actually on international family and civil hot topics. Now, families can be quite complicated, and we got these experts who really have great first-hand knowledge of how complicated things can be when there are some international issues. We have a wonderful moderator today, one of our team members, organizing team members, Ms. Mine Gür. Ms. Gür hails from Istanbul. She's a graduate of Marmara University Faculty of Law, and she got her LLM degree at the Boston University School of Law in Boston, Massachusetts. And she owns her own private practice in New York City for the time being. And Ms. Gür will introduce our team, and thank you very much. We will be ending this exactly in 50 minutes, which is going to be precisely 12:30. And we will save 5 minutes for questions at 12:25. Thank you.
Good morning. Welcome to International Family Law and Civil Law panel. We have two outstanding guest speakers today. Our first guest speaker is Professor Nuray Ekşi. Professor Nuray Ekşi is currently head of Private International Law Department at Yeditepe University in Istanbul, Turkey. She had her law degree from Marmara University in 1987. She has a PhD in international jurisdiction of the Turkish courts. She is the author of more than 20 books in private international law. Today, she is going to talk about recognition and enforcement of foreign court decisions in Turkey. Also, procedure of recognition or enforcement, conditions for recognition and enforcement with particular reference public policy will be evaluated during this panel. Our second guest speaker is Jeremy Morley. He was admitted to New York Bar in 1975. His practice concentrates international family law. He is the co-founder and partner of Law Office of Jeremy Morley. He has more than 40 years of experience in international family law. Mr. Morley is the author of International Family Law Practice and also the author of the Hague Abduction Convention, Practical Issues and Procedures for Family Lawyers, published by the American Bar Association. Mr. Morley will be speaking to prevention and child abduction prevention and recovery issues. Thank you. Let's begin with our first speaker.
Thank you. Thank you, Mr. Chairman. My subject is recognition and enforcement of foreign judgments in Turkey. I would like to make a very brief overview regarding that issue. The Turkish law has, since 1918, permitted the enforcement of foreign judgments in civil and commercial matters. The issue of the recognition and enforcement of foreign judgments under Turkish law has gone through the following four periods. The first period is Enforcement of Foreign Judgments Act on Ottoman Empire. The second one is the Turkish Civil Procedural Code. And the third one is the former Private International Law Act. And the fourth one is the Private International Law Act. This is the current act which has been in force since 2007. Turkish private international and procedural law provides the provisions regarding the enforcement and regarding the recognition and enforcement of foreign judgments. However, there are other legal sources for recognition and enforcement of foreign judgments. These are the multilateral international conventions and the bilateral treaties concluded by Turkey with certain countries. But I must be clarified that Turkey is not a party to the Hague Convention on the recognition and enforcement of foreign judgments in civil and commercial matters, which is concluded in 1971 in The Hague. Multilateral conventions to which Turkey is a party and which consist of provisions regarding recognition and enforcement of foreign judgments can be seen from my PowerPoint. As you can see, there are so many multilateral conventions containing provisions on recognition and enforcement. Besides these multilateral conventions, as I said before, Turkey has concluded certain bilateral treaties with the countries listed in my PowerPoint as well. Starting from 1927, Turkey has concluded bilateral treaties. Those treaties consist of recognition and enforcement provisions, but also the other areas regarding the judicial cooperation. The procedure and conditions for the recognition and enforcement of foreign judgments is basically provided by Private International Law Act, and according to the Article 52, Paragraph 1 of the Private International Law Act, a foreign judgment shall be enforceable upon the application by any interested party. Therefore, the parties of the foreign proceeding can be different from the parties to the enforcement proceeding pending in Turkish court. In accordance with the Turkish Court of Appeal judgments, the most typical exceptions to the requirements that only the parties to the original proceeding may apply for recognition concern successors and Social Security Agency. Although both are not party to the foreign proceedings, they are accepted as interested parties for the recognition proceedings pending in a Turkish court. The Turkish Court of Appeal instantly ruled that, in its former judgments, the successors of the person who obtained a divorce judgment before a foreign court, but after obtaining this court judgments died, cannot apply for the recognition of foreign divorce judgments. But fortunately, the Court of Appeal has changed its former judgments after the judgment granted by the European Court of Human Rights in Selin Öztürk Turkey case. I would like to mention the material facts of this case. When Ms. Öztürk's father died, he had already divorced from his ex-wife by the judgment of a German court. However, his father had not applied to the Turkish court for recognition of the judgment. Ms. Öztürk requested the Turkish court to recognize her father's divorce judgment rendered by the German court. The Turkish court refused to recognize the German court's judgment. In coming to this conclusion, the Turkish court relied on the jurisprudence of the Court of Appeal that only the parties to the original proceedings may apply for recognition. As the German judgment was not recognized in Turkey, the ex-wife of the father also became a successor. Pursuant to Article 599 of the Turkish Civil Code, the applicant received the 3/4 of the estate, whereas the rest went to the ex-wife or ex-wife of the deceased. The European Court of Human Rights considered that, insofar as the applicant was deprived of a quarter of estate of her father, the refusal of the Turkish court to grant recognition of foreign judgment is the violation of European Human Rights Convention as well as the protocols relating to this convention. Similarly, in its decision, the Court of Appeal in 2009 ruled that Social Security Agency, which was not party to the original divorce proceeding conducted in the Netherlands, had a legal interest in commencing a legal proceeding for recognition in Turkey. In that case, a Turkish citizen who had divorced from her husband by the judgment of by a judgment of Dutch court applied to the Social Security Agency to receive a widow's salary. The Social Security Agency then commenced a legal action for the recognition of foreign judgment's decision. The Court of First Instance turned down the request, but the Court of Appeal overruled the Court of First Instance on the ground that Article 52 of the Private International Law Act allows any person having any legal interest in recognition of foreign judgments to apply for recognition. Now I would like to turn to the main or substantive conditions for recognition. Conditions for recognition and enforcement of foreign judgments can be divided into three groups. The first group is preliminary condition, and the second group is substantive condition, and the third group is the complementary conditions. The preliminary conditions for the recognition and enforcement of foreign judgments are as follows. The first one is there must be a judgment given by a foreign court, and the second is the foreign judgment must be final and conclusive, and the third is the foreign judgments must be concern civil and commercial matters. Foreign decisions could be judicial or non-judicial nature. However, Turkish private international law provides only recognition or enforcement of foreign judicial judgments, foreign judicial decisions. It is not possible under Turkish Private International Law Act to recognize or enforce non-judicial decisions in Turkey. However, multilateral conventions that are listed in my PowerPoint accept the recognition or enforcement of non-judicial decisions as well, but now I am just only referring to the Turkish Private International Law provisions. In certain countries, divorce decisions, succession certificates, or guardianship decisions may be issued either by municipalities or notaries public or religious bodies. As Article 50 of Private International Law Act refers to the decisions made by the foreign courts, decisions issued by foreign notaries or municipalities or other administrative units cannot be enforced in Turkey. Sometimes cases filed before Turkish courts seeking the recognition in Turkey of Danish administrative divorces or Japanese Kyogi-Rikon divorces. Therefore, Danish administrative or Kyogi-Rikon Japanese divorces are the main examples of the Turkish courts practice relating to the recognition of non-judicial decisions in Turkey. The Second Chamber of Court of Appeal in 1995 approved the decisions of lower court rejecting a request for the recognition of a divorce decisions made by the Copenhagen municipality on the ground that that wasn't a court judgment. The Court of Appeal stressed that only the foreign court judgments can be recognized or enforced in Turkey, as this divorce decision is granted by the Copenhagen municipality. It cannot be enforced under the Private International Law Act. The Court of Appeal repeated the same conclusion in another case in 1998, this case also relating to the Dutch administrative divorce confirmed by the municipality, and the Court of Appeal refused the recognition of this divorce decision in Turkey. Japanese Civil Code, Article 763, allows supposers to sign a contract which operates as a decision on their own divorce. In one case, a Turkish husband, a Japanese wife, signed a divorce contract without involvement of any judicial authority in Japan, and this contract was approved by the mayor of the Shinagawa. The Turkish translation of the divorce document was prepared by the consular section of the Turkish embassy in Turkey. The divorce decision which is ratified by the municipality in Japan, was initiated in Turkey seeking for recognition. However, the case was dismissed on the ground that the divorce decision at issue has not been made by a Japanese court. Therefore, recognition of this decision is refused by the Turkish court. Another example for non-judicial decisions which are not acceptable to recognize or enforce in Turkey is the decisions on guardianship. In Germany, there is a state which is called Baden-Württemberg, and under Baden-Württemberg law, the guardianship decisions can be given by notaries public. And in one case, a Turkish national obtained a guardianship decision for his father, and he wanted to enforce these judgments in Turkey, but Turkish court refused to recognize and enforce the guardianship decision made by the German notary, because this is a non-judicial decision. I would like to turn to the substantive condition for recognition and enforcement of foreign judgments. Reciprocity is the main requirement for the enforcement proceedings in Turkey, but I must say that for the recognition of foreign judgments in Turkey, reciprocity is not required. Reciprocity has three different types. There should be either a statutory reciprocity or reciprocity agreement between Turkey and the state where the judgment has been rendered. Or it could be actual practice in that state which enables the enforcement of Turkish court judgments. Reciprocity based on the treaties is realized through the aforementioned multilateral and bilateral treaties. Further recognition or enforcement is addressed nearly in every state law, and in principle, legal instruments addressing recognition or enforcement constitute the basis of statutory reciprocity. One type of reciprocity suffices to satisfy the reciprocity requirement. For example, the Turkish Court of Appeal has ruled that there is a statutory reciprocity between Turkey and the U.S., while recognition or enforcement of foreign judgments has a statutory basis in the United States. The second chamber of the Court of Appeal approved that although there is no bilateral treaty between Turkey and the U.S., this statutory reciprocity between the states of Alabama and Turkey satisfies the requirement of reciprocity. The second condition, substantive condition for recognition and enforcement of foreign judgments in Turkey is no review of the merits. A substantive review of the foreign judgments is not permitted under Turkish Private International Law Act, save as public policy requirement. In no circumstances may the Turkish court review the merits or substance of the foreign judgments. Exclusive jurisdiction of Turkish courts and exorbitant jurisdiction of the foreign court are the obstacles for recognition and enforcement of foreign judgments in Turkey. Both the academia and the jurisprudence has expressed the view that typically it is the cases concerning real rights that come under the exclusive jurisdiction of Turkish courts. In 1985, Bodrum Court of First Instance, Bodrum is a province in Turkey, partly rejected the recognition of a judgment given by a New Jersey district court ordering the divorce of a couple and the transfer of the ownership of real rights in Bodrum from the American citizen to a Turkish citizen. The Bodrum Court of First Instance ruled that since the Turkish courts have exclusive jurisdiction over the real estate located in Turkey, the part of the New Jersey judgments relating to transferring the property to the wife is not recognized or enforced in Turkey. The third condition for enforcement of foreign judgments is that violation of the right to defense. Respect of the right to defense is one of the requirements for recognition and enforcement of foreign judgments in Turkey. There are so many jurisprudence of the Court of Appeal, but as I have a limited time, I cannot make any reference to those jurisprudence. Public policy is the last requirement for recognition and enforcement of foreign judgments. Public policy should operate only in exceptional cases and cannot be used as a tool for reviewing the merits of foreign judgments. Public policy cannot be invoked on the ground that the original judgment involved an error of law. Similarly, the accuracy of the findings of the fact made by the court of the state of original cannot be reviewed. There should be no recourse to public policy, even if the court of the state of origin applied a law which is totally different from the Turkish law. According to the Turkish Court of Appeal, when a foreign judgment infringes fundamental principles of law or basic rights and freedoms guaranteed under by the Constitution or by the international instruments or public morals, it is deemed to be incompatible with the public policy. Let us note here that European Court of Human Rights accepted that a court requested to enforce a foreign judgments needs to only carry out a limited review of the judgment's compatibility with the European Convention on Human Rights. There are certain foreign judgments which deserve particular attention regarding the Turkish public policy. I can summarize them under the headings you can see from my PowerPoint. One of them is the insufficiently reasoned foreign judgments. Insufficiently reasoned foreign judgments could be contrary to the public policy. Initially, the Court of Appeal refused to recognize or enforce foreign judgments which had no reasoning or which were regarded as being insufficiently reasoned. This issue came up in the enforcement of judgments granted by the German courts under the Mannverfahren proceedings. I would like to clarify what is Mannverfahren proceedings under German law. In accordance with the Mannverfahren, the claimant who has certain types of documents can apply to the German courts to obtain an execution order. The German court may draft an execution order without holding a trial and serve it on the respondent. If the respondent does not object to the execution order, it becomes final and conclusive. While some chambers of the Court of Appeal refuse to recognize those types of judgments, the others take the opposite view and accept the recognition of those judgments. However, the differences between the chambers' view are faded away by the General Assembly in 2012, and the General Assembly ruled that insufficiently reasoned foreign judgments are not contrary to the public policy. Punitive damages could be contrary to the Turkish public policy, although the Turkish Court of Appeal has not dealt with with enforcement of punitive damages granted by the U.S. courts. The overwhelming view is that non-compensatory damages, such as exemplary or punitive damages, shall be contrary to the Turkish public policy. Discussions on the enforcement of punitive damages in Turkey started with the judgments of New York District Court judgments granted in 2003 relating to the case between Motorola Nokia and the Uzans family. In this judgment, Judge Rakov refused the arbitration and jurisdiction objections made by the Uzans family and ordered a compensation of 4.2 billion against Uzans family, which include 2.1 million punitive damages. As the enforcement procedure relating to Rakov's judgment was not commenced in Turkey, it is difficult to predict what approach the Court of Appeal will take regarding the enforcement of punitive in Turkey. However, I can say that the academia mostly comments that punitive damages are contrary to the Turkish public policy. Another issue that will deserve special attention is the anti-suit injunctions. According to the views expressed in the Turkish academia, including my opinion, anti-suit injunctions should not be enforceable in Turkey because they are contrary not only to the Turkish public policy, but also to the principle of fair trial guaranteed under the European Human Rights Convention in Article 6. The other title could deserve a special attention is the foreign joint custody judgments. The Turkish Court of Appeal has consistently emphasized that foreign joint custody judgments cannot be recognized in Turkey as they are contrary to the Turkish public policy. In our view, however, the mere fact that the foreign judgments permit joint custody should not in itself be a ground to reject the request for enforcement of foreign judgments. Rather, Turkish court should examine whether such joint custody is in the interest of the child and should reject the request for enforcement only where the joint custody is found not to be in the child's interest. Foreign judgments which violate fair trial, as I said before, is another reason for refusing the recognition or enforcement of foreign judgments. And foreign judgments relating to real property in Turkey, located in Turkey, cannot be recognized or enforced in Turkey. As I mentioned, the Bodrum Court of Instance judgments, those types of foreign judgments fell into the exclusive jurisdiction of Turkish courts. Therefore, they are not accepted as enforceable in Turkey. Foreign bankruptcy decrees also is a hot topic over which different opinions have been put forward, not only in the academia but also in the practice. The Court of Appeal in 1969 refused the Italian insolvency order recognition in Turkey. However, the Turkish Court of Appeal took another opposite view regarding the recognition of a bankruptcy order granted by the Turkish Republic of Northern Cyprus Court. Some Turkish scholars are of the view that foreign insolvency judgments are contrary to the Turkish public policy, and the recognition of such judgments is not permitted as the Turkish courts have exclusive jurisdiction over bankruptcy orders. Others argue that the incompatibility with Turkish public policy of recognition of foreign bankruptcy decrees should be assessed on a case-by-case basis. Enforcing a foreign gambling debts could be found contrary to the Turkish public policy. There is no any Court of Appeal judgments up to now, but there is no such a case in Turkey, but it could be happen in the near future, because there are some countries where the Turkish people go and play gambling, and there could be some legal proceedings against those Turkish people who gambled in a foreign country. Another and last issue that I would like to touch upon is the TALC conducted abroad. First, I would like to mention what is TALC means. TALC is a divorce type which is accepted by some Muslim countries. That means that a man could say his wife, talak, talak, talak. That means that I divorce you, I divorce you, I divorce you. Each Islamic country has a separate procedure for talak. Some of them requires the registration of talak by court or by a religious institutions. But just here I am talking about the talak